Welcome back to Inland Empire Car and Truck Accident Law with Deborah Song. I'm Abby, and today I'm here with Deborah Song from Empire Law. Good to have you back, Deborah.
Good to be back. Thank you, Abby.
Today, we are answering the question everyone types into their phone after a truck crash. What is my case actually worth? And there is nowhere this matters more than the Inland Empire. Between the I-10, I-15, and I-215 freight corridors and the warehouses packed in around Norco, Eastvale, and the rest of the region, this is one of the biggest logistics and freight hubs in the country, which means a lot of commercial trucks and a lot of serious crashes. And a truck accident settlement looks nothing like a regular car accident settlement. Today, Deborah breaks down exactly what drives that number up, what can drag it down, and how a family actually gets the full value. So, when we talk about what a truck accident case is worth here in the Inland Empire, what actually determines that number?
A truck accident settlement value isn't a random sticker price. It's carefully assembled based on the total harm done to you. We typically look at three main things. Number one being what you lost. Number two being how much insurance coverage is available. And the last thing being unique factors that can raise or lower that number. Everything starts with your complete damages, both the economic bills, this would be like your lost wages, your medical bills, any out of pocket expenses for reimbursement, rental, things of that nature, things that you can calculate using a calculator. And then the other side of the damages is going to be the non economic human toll. And that will be what you typically hear as people saying pain and suffering. It's the stuff that you can't really calculate with the calculator. It's your daily grind, the daily effects of the accident and your injuries and how it affects you and what kind of changes it's caused in your life.
Most people assume a truck case is just a bigger version of a car case. It is a different animal, and it is worth saying why. Why is a truck accident settlement usually worth so much more than a regular car accident settlement?
Typically, a commercial truck weighs around 80,000 pounds. And so that kind of weight, when it's being impacted against your car, it causes far more severe and catastrophic injuries than a typical passenger car would if it had hit your car in the same way. And that fact, in and of itself, naturally drives up the value of the case. And the other thing is commercial trucking insurance policies. They have a legal requirement. So in California, with our passenger cars, we have what's called the California minimum requirement to drive around with at least $30,000 worth of liability coverage for your vehicle when you're driving around a regular passenger car. But the same kind of limitation applies for these commercial trucking insurance policies. They are legally required to be a far larger standard policy than a normal personal auto insurance policy. And because of the nature of the impact and the amount of weight that's put into your car and your body, the injuries that you sustain are typically more severe. And then combining that with the massive insurance limits ultimately means that these numbers completely change the landscape of the value of the case. And because the value is so high, the trucking company will usually launch a much more aggressive defense because they have a lot more to lose. And that's why it's even more important that you build an airtight case.
So, value comes down to your losses, the money behind the truck, and the factors that move that number. Let's start with the losses because that is where cases get won or quietly undersold. So, break the number into its pieces and start with the hard costs anyone can see on paper. What economic damages actually go into a truck accident settlement?
One of the things that is considered an economic damage is what you have in terms of medical bills. Not only the medical bills that you've incurred as like a single receipt from your initial ER visit or the physical therapy that you did, but it also includes your future medical bills that you reasonably see yourself doing in the future due to recommendations from a doctor or due to something that a doctor has told you that you will reasonably need. Whether you get it or not, that's considered a future medical bill. And that is also included in the economic damages. And then also on top of the economic medical bills, past and future, you have lost money from work, any wages you missed right after the crash, plus lost earning capacity. Meaning, if your injuries have caused you to, let's say, no longer be able to function the way you did and perform at work the way you did before, and that causes you to either lose your job and you have to look for a new job, or you're not fully functioning the way you used to, and you have to do a demotion or a lateral change, and it changes your income coming in. So that would be loss of earning capacity. And that's an injury that prevents you from making what you used to do. Then you have your out of pocket cost. And these are things that people typically pay out of pocket that would capture things like property damage. A lot of times when you go in to go fix your car, or even when you get your car totaled, if you go through your own insurance company, you more likely than not have what's called a deductible that you have to pay. And whether that be 500, 1,000, sometimes I've seen it as high as 2,000, that is an out of pocket cost that you end up ultimately having to eat. And so that's something that we would want to submit to the other side. And sometimes people, when they don't have rental coverage, they end up having to use other modes of transportation, let's say a bus, or they have to get a rental. If they have to use things like Lyfts or Ubers, rideshare apps, transportations to doctors, any kinds of receipts, out of pocket expenses for those can also be asked for as far as reimbursement goes. And then these kinds of economic damages are the solid foundation of your case because they are documented in black and white. So it's very easy to calculate. It's easy for the other side to see. Yes, these are receipts, these are numbers. They can see where it's coming from.
The part people struggle to picture is the human side. So, walk them through how it actually gets valued. How do you put a dollar figure on something like pain and suffering?
It's very hard to put a certain number to something that we call human losses. These aren't things where you can pull up a receipt or calculate easily in the back of your hand. They are what we call human harm. And in our legal world, it's called non economic damages. And they're designed to somehow compensate you for the physical pain, the sleepless nights, and the reality of a life that you can't live the same way anymore. It's more of when you are injured due to someone else's negligence, they are required to put you back into a spot where you used to be prior to the accident happening. But sometimes with these injuries, they can't do that. They can't just reimburse you for your deductible and then that's it. There's a lot more to it. And it's something that you can't fix. And if you can't fix it, the least they can do is give you money for it. But the adjusters and how the juries value it is they typically take a close look about your injuries and how severe your injuries are, whether they're permanent, and if they're not permanent, how long will it take for you to recover, and just how much of your daily life has changed. Different attorneys go about it in different ways depending on the trial, and some attorneys, they will do like a per day. And so they'll say, okay, this is the kind of things that my client has been going through. Every day they have to be in a wheelchair, or every day they have to ask their coworkers for help to pick up and lift heavier objects. Now, how much is that worth? So to easily calculate it, they'll say, okay, so if this client has to live with this kind of pain for the rest of their life, every single day, let's give them $20. Let's give them $50. Let's give them $100 just to put a number on it. And for the rest of their life, that's actually determined by a Casey jury instruction as well. So if you look at the charts, there's actually a chart that will tell you based off you can just Google it too, but based off of your demographics, there is a life expectancy to you. And so that is the legal life expectancy that you will be allowed to claim for the rest of your life. And if you add that up every day, that's how they come up with these numbers. They call that per diem. Now, the other route is typically a little bit less calculative, and it depends on your jury as well. The attorneys want to make sure that it's something that'll register with the jury. And if a per diem calculation is not going to work, sometimes they like to use bigger analogies. Let's say the government fighter jet. Let's say a government fighter jet is worth $2 billion, right? Each one of those fighter jets costs a lot of money to make. And even if it's so expensive, if there's ever a situation, an emergency situation where the pilot needs to escape because the jet is going to go down for whatever reason, then the pilot is required to eject himself and make sure that he is safe. So sometimes analogies like that a single human life is worth more than a government $2 billion fighter jet. So things of that nature. It's different on how we approach things, but it depends on the serious nature of your injuries. But ultimately, insurance companies, they love to pay the bare receipts. They only want to pay bare minimum, and they completely ignore, whether intentionally or unintentionally, because these claim adjusters, they have thousands of these claims on their desks. So it sometimes becomes just a number to them. You are legit what we call a claim number. That's how they see you. And so it's important to make yourself known, and you tell them about all these sufferings that you have in detail using examples so that they can really relate to you and see, oh, okay, it's not the typical generic, oh, I can't hike anymore, which is what we hear a lot, but we don't let them do that.
A lot of settlements shortchange the future. So make the case for costs that have not hit yet. What are future medical expenses, and how does a case pay for care you have not needed yet?
So you shouldn't be having to pay out of pocket later if the injury is what's causing those out of pocket expenses in the future. And what we were talking about a little bit earlier was the economic damages, including the future medical bills. That's what these would cover. So if a doctor says, hey, you need surgery, or hey, you need physical therapy, you need this many sessions of it, then you can easily calculate that based off of, if sometimes doctors are good about it and they'll actually write it down for you and they'll tell you this is how much it's going to be. Or let's say, for example, therapy, if you need future therapy and you've got it done before, it's easy to calculate based off of the therapy you've done before. You just use that number, however much it was for each session, and you multiply that by however many sessions you need in the future. And however many years you're going to need it down in the future, you just multiply it. And we don't just pull a number out of thin air. If we get to a point of litigation where we need to hire these guys, there are medical and financial experts. They're called life care planners. It's their job to actually crunch these numbers with your life expectancies and project these costs. And then they will put a report together called a life care plan. And that's what is presented to the jury. And of course, the other side, they'll have their own life care planner that they've hired, who will also say, oh, actually, no, this person is not expected to live this long, or due to this situation. Or they'll say something like, I don't think this much of this kind of treatment is necessary. Their goal is to minimize it. So ultimately, you'll have two life care planners with two different numbers, and it'll be up to the jury to decide which one to go with, or somewhere in between. And this is valued after you've reached what we call maximum medical improvement. It's MMI for short, but typically you don't bring a life care planner in until you have done everything that you can to recover from your injuries, and there's pretty much nothing more that you can do to get better, but there's things that you can do to maintain your status quo. So you've kind of reached the plateau. You're not going to get any better than this, but to keep at that new baseline and to not go lower than that, you have to continue with, let's say, therapy, let's say you need to continue with psych treatments, things of that nature to just make sure that you're not dipping back down. So that's where you start putting in the long-term medical picture. And that calculation is what makes it a lot more clear of what your damages are. And so settling your case before calculating these future costs and before fully mapping this out is exactly how people run out of medical money later on after a settlement has been accepted.
So, for the worst cases, one document, like you mentioned, tends to carry the whole future. So, what is a life care plan and why does it matter so much in a catastrophic case?
In a catastrophic case, these life care plans are built by experts and it projects every single medical and care that an injured person needs for the rest of their life. It becomes the absolute center of a lawsuit when it comes to someone who suffered a catastrophic injury requiring the long term care. These are going to be things that are thought out not only by the doctors, but the life care planner itself. We've had a case where they even contemplated having an in home nurse. And so it'll calculate and see how much it'll cost to have an in home nurse for the rest of that person's life. And then it'll also contemplate for situations where, let's say, the mother can't be available and they're going to need emergency backup or things of that nature. It'll also calculate for a car, a vehicle that's specifically used for people that are paraplegic. Let's say that is the injury that you sustained and how much it'll cost to maintain that vehicle for the rest of that person's life. And if it does die out, if it's scheduled to, if there's experts out there that can calculate that, it will make sure that they get more money to buy another car if it's reasonably expected to give out after, let's say, 100,000 miles. So things of that nature, they think of everything and make sure that nothing is missed. And it's good that we have stuff like that because us as lawyers, we wouldn't know any of that. And so we don't just leave it up to our guess and we don't just leave it up to just throwing random numbers in the air. It's put together by experts, and that's usually who battles it out on the trial floor if it gets to that point. And ultimately, it's the kind of documentation that this human needs. And it's a concrete number that an insurance company can't easily dismiss. Unlike, let's say, a per diem argument for pain and suffering, that's a little bit more kind of subjective. It'll be different based off of what I think compared to somebody else. But these are numbers that basically turn something that can be a little speculative and turn it into something more real and something that a jury can really grasp and calculate with their calculator.
For a lot of clients, the biggest loss is not the medical bill, it is the career. So let's spell that out. When someone can no longer work, how does lost earning capacity get valued?
Lost earning capacity looks at the total lifetime income that the injury will cost you going forward. So there's experts for this as well. And these career experts, they're usually considered like vocational rehab experts, but they are designed to evaluate based on your injury and what your physical limitations are, what you are realistically capable of earning before the crash versus what you can now earn due to having these injuries. And for example, we had a case where the client was a commercial fisherman at the Long Beach port. Now, these Long Beach ports and these particular positions are very special because they're so highly coveted and you can only have a certain number of crew members on each boat. And it's not like these are unlimited number of boats. Each port has a limited number of boats, and once the boats are filled, they're filled. Once the crew members are put together, they're put together. And that's all this client knew. They didn't go to school for anything else. That's what they did. That's what they grew up with. That's all they knew. And due to the injury that he had sustained, he could no longer do that job. It required a lot of back muscle, which after the back injury, he could no longer do without causing extreme discomfort and further injuries to his back. And so this vocational expert, what they would do is okay, now you can't do those kinds of physically excruciating jobs and jobs that are physically demanding. You have to do something more like a desk job, or you have to do something more that's low key, cash register position, something that's not as demanding. And those kinds of price differences with these, how much they make as a commercial fisherman versus how much they are now able to make just being a bagger boy or working at McDonald's or things like that on a cash register, they will determine how much lost earnings you will potentially have for the rest of your life. And this kind of sits right alongside your medical bills calculations, too. It's easily one of the largest financial pieces of a lawsuit, depending on the severity of your injuries and what it has done to your potential to earn income in the future. And it's worse when it's a young person. When a young person's career is cut short, that loss of capacity of earnings can be worth significantly more than a single hospital bill because that loss of earning capacity now has a long life expectancy they have to put into play.
So, tie the severity of the injury directly to the size of the case because that's not obvious to a listener. Why do catastrophic injuries like a brain or spinal cord injury push the value up so much?
A traumatic brain injury, in short, in acronym, it's called a TBI, or a spinal cord injury, permanently changes everything about how a person lives and interacts with the world. You have to think about them as decades of specialized medical care, and that in and of itself drastically inflates the numbers in a life care plan. These medical needs, the lost career capacity, and pain and suffering, they all grow exponentially based on the sheer severity of the injury. And these are heavy, high stake cases where meticulous and complete valuation makes the biggest difference.
Those are the pieces of harm we add up, but here is what really separates a truck case: the sheer amount of insurance sitting behind the truck. So let's talk about the money. Here is the piece that genuinely sets a truck case apart, and it is good news for victims. So, set it up plainly. Why do truck accident cases involve so much more insurance than a car crash?
Commercial trucks cross state lines, and interstate carriers, meaning commercial trucks that are allowed to cross borders and allowed to go into different states, they carry a higher risk of getting into accidents with people because they are exposed to more people. So, federally, by federal law, they are mandated to carry a minimum of $750,000 in liability policy, which is way higher than a regular car's minimum of 30,000 currently. In reality, most commercial trucking insurance policies are worth multiple millions of dollars. So even if it, let's say it is 750 or 1 million, they usually have what we call an excess policy. If your injuries are worth more than the $1 million, they usually have layers and layers that you kind of peel back and unfold as your injuries are worsened. And then you can see there's a whole lot more layers of insurance on top of that. And the Federal Motor Carrier Safety Administration, this is the administration is called the FMCSA. It's a government body that sets these heavy coverage floors. So they control what is required for these commercial carriers to have. We have the I-10, the I-15, the I-215. All of these freeways are interstate travel. We have usually 1 or 2 lanes just fully backed up with these commercial carriers because they're just traveling around interstate. And you can just think about it. Each one of them, they have a heavy coverage with them as long as the drivers are covered.
People hear big insurance and assume unlimited money, but what is the federal minimum coverage and how do policy limits actually work?
$750,000 policy limit is the bare minimum requirement. It's not a maximum cap on what you can recover. We look for what they call layers of coverage. These are not only the $750,000 policy limits, but there's something called coverage stacking. And so each of these companies, they usually have insurance on top of insurance on top of insurance, and they each kind of kick in every time you exhaust one of the layers. And that usually means we can combine multiple different insurance policies into one larger pool, and depending on the injuries. And of course, that it is something that we are looking to do. And identifying every commercial trucking insurance policy involved shapes the entire legal strategy from day one. Usually, it's not something that's disclosed in what we call the pre-litigation world, which is prior to filing a lawsuit. Even after you file a lawsuit, the other side will really push back on disclosing those to you. And it's because they don't want you to know how much they actually have. A lot of the times they'll argue, well, you don't need to know that because it's not like your case is worth over whatever it is that I just disclosed. The first layer, maybe the first two layers. But if they usually have like 3, 4, 5 layers, they'll usually not disclose that. And so it's something that the lawyers have to fight for. Usually we'll have to file what we call a motion to compel with the court. And we go in front of the judge and we tell them, hey, these guys are being shady. There's more coverage. They don't want to tell us. Your Honor, please make them tell us. And so these available insurance coverages, it dictates the practical limit of what we can recover. That's why we need to aggressively hunt for these policies and know what they have available. Because depending on what our clients' injuries are, if we believe them based off of what they tell us, we could be leaving a lot of money on the table that our client should have been able to access, but now they are limited because we didn't do our due diligence and we didn't figure that out. And they are now left with outstanding out-of-pocket expenses in the future because they didn't get paid that through the other insurance policies that were available.
And more defendants usually means more money. So walk through everyone who can share the blame. So beyond the driver, who else can be on the hook and why does that increase what you can recover?
These are a little bit more rare of situations, but it has happened before. I've been involved in a situation where we had to look for these. We just scraped through them because there are sometimes carriers and commercial carriers that are maybe a smaller company. So maybe they don't have layers to pull back. Maybe all they do is have the $1 million that they have available and nothing more. But if the injuries are a lot more severe, then we will go and try to bring in other defendants, bring in other parties who could have been responsible for these injuries, not just the truck driver. So bringing in things like the broker or bringing in the shipper or even the owner, the CEO of the company, it expands the sources of money available to make you whole because each of these companies, the broker, the shipper, usually the CEO, they might not have coverage that could apply, but usually they will have the assets to cover for the injuries too and help. But each of these people, like the broker and the shipper, they usually have their own insurance companies. So you kind of stack them all together and pull all the money in to make sure that your client is made whole. To bring in different kinds of owners, CEOs, or different higher up companies that were, let's say, maybe in charge of telling the carrier where to go, whoever hired the carrier to do the shipment of chicken or whatever it may be. There's legal theories and legal rules in our world that we call things like vicarious liability or Respondeat superior, which is a Latin term that holds these trucking companies and these other outside companies responsible for the careless actions of this driver, even though they might not be the direct employer. The carrier, cargo broker, shipper, even sometimes an outside maintenance contractor can share in that blame. Every extra defendant we find usually means another commercial insurance policy we can tap into for your recovery.
So there is usually a much bigger pool to reach. Now let's talk about the factors that push your number up and the one that can pull it down. Some cases have a factor that can multiply the value. Explain when that door opens. When can punitive damages come into a trucking case and how do they change the number?
Punitive damages are specifically meant to punish the defendant for shockingly bad conduct, not just ordinary mistakes. There is a case that I've had where the punitive damages came into play when the company has hired one person to deliver this good, right? This particular good and across interstate lines, and it's a long distance. And by law, they are required to have, let's say, two people on the truck to make sure that they're taking turns at driving. So one is not getting tired or the other. And then to save cost, the company deliberately intentionally chose to only have one driver, and they kept the delivery date. If you're only going to have one driver, then they need to have their breaks and the delivery date needs to be doubled and give them double time because they don't have the alternate people. So in that situation, that one truck driver was driving across interstate lines, tired. And in a situation like that, they are usually going to lose focus. And that's exactly what the law is designed to protect against the consumers from being hit by these 80,000-pound trucks with reckless drivers or tired drivers and cause a lot of these injuries. And so in situations like that, you use the intent of the company, you use their deliberate, willful conduct and choosing to not have that second driver, and then you use that to punish the company. And you say, hey, you need to learn your lesson, never do this again. And it's a separate pot of money that you ask for. It's a money that is designed to punish the employer, to deter them from doing this again in the future.
Clear up the fear that keeps people from calling and be direct that partial fault is not the end. If I was partly at fault myself, does that wreck my case here in Norco, California?
No, because in California, we use what's called the pure comparative negligence system. This means you can still get compensation even if you were partly or even mostly at fault. It just whatever your damages are, the amount that you can collect is limited to the percentage of fault that's placed on the other driver. So if you are, let's say, 99% at fault, then you still have that 1% that you can recover. So whatever your total damages are, you multiply that by 1%, and that is how much you can recover.
All of this only works if you can prove it. So let's talk about the evidence that establishes what a case is worth. So a number is only as strong as the proof behind it. So name the evidence that moves an adjuster. What evidence actually proves what a case is worth? The black box, the logs, the reconstruction?
The electronic logging devices, these are called ELDs, and the black box data that you're talking about earlier, these are all data that an expert can pull from the vehicle itself, and it'll show different things based off of what kind of vehicle it is, but certain things like, let's say, the truck's speed or when the driver hit the brakes and how long that car had been or that truck had been in motion and how long it was driving for before it had its last break. Things of that nature is stuff that can be pulled from those datas from those vehicles using experts. And then, of course, a lot of these commercial carriers, because they're required to have such a high policy, a lot of these insurance companies, they will incentivize the owners, the companies, to put dash cam inside of their trucks to potentially save the insurance companies from having to pay out. So if the company agrees to put dash cam in their fleet of trucks, then they'll have a lower premium that they pay. So a lot of these truck drivers do have dash cam footage. And of course, you will have to send the agent of service of process of that company a preservation letter from the moment that the incident happens. I would say you have about a week before the dash cam footage just gets recorded over to make sure that they keep that footage, they don't destroy that footage, just in case this case ends up needing to go to litigation and they have to give that copy over to you.
The clock on evidence is different from the legal deadline, and people don't always know that. So, why does acting fast matter so much for preserving the evidence that drives value?
The faster you act, the more of the evidence is preserved. The longer you wait, things will eventually somehow get thrown away, whether knowingly or unintentionally, just with time and protocol. Especially if you don't send out that preservation letter, then they really have no legal obligation to keep anything. So electronic data routinely gets overwritten, dash cam footage as well gets overwritten. And so the faster you act, the risk of the defense destroying or losing the evidence is minimized.
So, once you have built the value and proven it, the last question is how you actually collect it. So, let's walk through getting paid. Take the mystery out of what happens after the demand goes out. Once the case is built and proven, how does the negotiation with the trucking insurer actually work?
Settlement negotiations are like a chess match. They are built on demands, counter offers, and leverage. So if you acted fast and you have the hard evidence and all your evidence is clearly documented, your damages are documented, you have the proper experts, you have all your ducks in a row, it puts a lot of pressure on these commercial insurance companies to pay up because you got your stuff together. But the more you wait and the less you have a chance of collecting all these little pieces of evidence later, unless, of course, it's like a life care plan, then obviously that doesn't change because you've already reached maximum medical improvement. But it gives the insurance companies every single little piece of evidence that you don't have is giving these insurance companies their own way to minimize your damages. So whatever loophole they can find, they will find, and they will put in their little defense arguments there. So as the more tight knit you can make your argument and leave as little to no space for the insurance company to come in and poke at it, it will change the value of the case.
Clients are shocked when the gross is not what they keep. So, explain liens before they see them. What are medical liens and how do they come out of a settlement?
Medical liens are legal claims from health providers or health insurance companies, and it's designed for them to get paid back out of your final settlement check. But depending on the kind of provider and who is asking for that reimbursement or the lien and the payment, it's different on the outcome. So it's a major part of a lawyer's job to make sure that these liens are in the best interest of the clients. If they are medical liens that are not being paid through health insurance, they are basically designed as an IOU, and it's basically the agreement between the lawyer, the doctor, and you all signing off on something saying, we promise to pay you after the case is over, whatever the result may be, because even if you lose, you still have to pay. So that's a big difference between a normal medical lien that hasn't been paid through health insurance and then a health insurance company lien, which is money that they've already paid out, and they're asking the client for money back based off of the amount of recovery we've recovered from the other side utilizing those bills, because it would be a windfall if we took those bills, submitted it to the other side, say, hey, pay me on these bills, and they do, then the health insurance company is saying, wait a second, you didn't pay for it. We paid for it, so give us that money back. And that is something that we can or cannot negotiate based off of the language of the policy, based off the laws of that health insurance plan.
We answer the fee question before you have to ask it. How does the contingency fee work? So, what do I actually take home at the end?
Contingency fee means your lawyers, we don't get paid a single cent unless we successfully recover money for you. So your final check is the total settlement minus the legal fees, the litigation costs, and the medical bills that we have to pay out. You don't have to pay anything out of pocket to open the case or to fight the massive trucking company. But afterwards, people that need to get paid, people that need to be reimbursed, they all are kind of like creditors. They all have first dibs on the settlement amount. Everything that's left over is your net take home number, and that is something that a transparent law firm will completely walk you through before you even sign a settlement agreement, hopefully.
There is one more thing that decides whether any of this matters, and that's the clock. So let's close on the deadline and what to do right now. So give people the hard date and make clear why the real clock is even shorter. What is the deadline to bring a truck accident claim here in Norco and all of California?
In California, you typically have a strict 2-year window from the date of crash to file an injury lawsuit. And I say typically because depending on certain situations, that can be limited and shortened to even as short as 6 months, or it can be extended to many years based off of how old you are. But there's different rules, but the general rule is 2 years. The general rule is 2 years from your personal injury to file a claim against the negligent driver. If a family is filing a claim for a lost loved one, that has a separate specific rule for timelines as well. But this is what we call the statute of limitations. It's basically a California law that limits your time to bring your case to court. And it's because the intent behind that law is to allow the defendant to know when they can feel a little bit more at ease. You can't just have this looming over their head for the rest of their life. You can't just bring it in 50 years down the line. They have to know that there's a certain point where they can kind of relax and realize, okay, you're not going to go after them anymore. So the sooner you act, the safer it is, not only for your evidence, but it's also safe for your chances of recovery. Because the moment that 2 years is up, you're done. Whatever offer was on the table can easily be taken off, and there could be zero recovery for you.
And who should a family in Norco or anywhere in the Inland Empire call to find out what their case is really worth?
If you are involved in a truck crash in Norco, in East Bell, or anywhere across the IE, the Inland Empire, that you'd reach out to us. My name is Deborah Song. We are with the Empire Law Truck and Car Accident Lawyers, and we can give you a free assessment on what your case is worth.
Deborah, if a family listening is trying to figure out what their truck accident case is worth, what is the one thing they should remember?
Document everything. I know it's hard to do when you're in that moment because you're full of adrenaline. You don't know what's going on, and it's hard to think. With our clients, after their case is over, I usually give them like this checklist, and I tell them to fold it and put it in their glove box so they don't really have to think about it. But there is a checklist, and I would say make that checklist of whatever we discussed today and make a list of whatever it is that you need to gather and just go through that list. So then you don't have to think about it too much and you know that you got it done. And documenting everything is going to protect the worth of your case.
If you or a loved one was hurt in a truck crash in Norco or anywhere across the Inland Empire, call Empire Law at 951-456-3891 or visit inlandinjury.com for free, no obligation case evaluation.